are we talking about today, Rosie?
Hello, everyone. Welcome back to Wilful Speaking with Rosie and Jim. Today, we're exploring some of the most unusual inheritances in the UK. Think eccentric millionaires, quirky wills, and the odd legal battle. The Great Stork Derby was a contest sparked by Charles Miller's will. He left his estate to the Toronto woman who had the most children in the 10 years following his death. It led to a baby boom and a legal circus, with several families vying for the prize. Quite the inheritance saga. In the end, 4 mothers, who each had 9 children during the 10 years, split the prize. How would something like that play out under UK law?
Wouldn't stand, I don't think. I mean, taking into consideration that with the Great Stork Derby, it was basically, he said that it was to the woman that had the most children in a 10-year period after his death. That's nuts. I mean, the court wouldn't even look at that in the United Kingdom because obviously here in England, we've got a modicum of common sense, whereas in Canada, maybe not.
Absolutely. In the UK, courts tend to favour more reasonable conditions. All right, next up, the case of a man who left his estate to Elvis Presley. This led to some interesting legal questions about bequests to public figures. How would a UK court handle such a bequest, Jim?
Well, if Elvis Presley was alive at the time that the will was created and was then brought before the probate courts and probate was granted, then Elvis Presley would inherit. But if the person has actually deceased, then it would probably go to the estate of Elvis Presley, to the Graceland estate. I mean, basically in UK law, you can give your assets to whoever you like. So, there's no stipulation that you can't give it to, the Queen or to the King of Monaco. You can give it to whoever you like. Obviously, it would then highlight certain things in regards to what was the state of the mind of the person that created the will at that particular juncture. Where did they have testamentary capacity? Was there any coercion or undue influence? Although, if it was given to Elvis, I can't see any undue influence there.
Spot on, Jim. Leaving assets to a public figure or their estate is legally possible. As long as the testator had capacity and wasn't influenced, the courts would ensure the will's terms are clear. Right, shall we move on to the next case? Let's talk about a British classic, the case of a man who left his entire estate to his local football club. This sparked a community debate and some legal scrutiny. How would that sort of bequest be handled, Jim?
Again, they would look at the testator, see, whether there was any issues with their state of mind when they created the will, whether there was any kind of coercion or any undue influence to give his estate to the football club. They would look at all of the background story in regards to why that particular bequest was actually made. But it would be legally valid in the first instance, and then obviously it would be down to other beneficiaries or other possible beneficiaries to contest it.
The club benefited from the bequest, and it became a local legend. Legal scrutiny ensured everything was above board. Quite a legacy for a fan, would you say?
Yeah, I would. Which football club was it?
It was for the club he supported his entire life, Hereford United. The bequest ensured the club received a financial boost, leaving a lasting impact on the community. Quite the dedication.
That is quite the dedication, especially for Hereford. I mean, if anybody gave that to Man City or Man U, I'm sure it would just get swallowed up. Yeah, let's have the next one.
Next, we have the case of a man who left his estate to fund a perpetual annual party for his friends. The courts ensured the party's terms were clear and within legal bounds. What do you think about that kind of legacy, Jim?
Hey, again, I mean, if you want to party on after, you're in the grave and I leave that kind of legacy, yeah. It would obviously need a little bit of policing and you would probably need to have some sort of mechanism in place. I would say a trust of some description to make sure that, that actually happened every particular year. So, yeah, I mean, it can be done, but it just needs a little bit of planning.
Setting up a trust would ensure the party goes on year after year as intended. It's a fun way to keep the spirit alive. Literally. Let's move on to the next case. How about the man who left his fortune to fund UFO research? Quite an out-of-this-world request, eh, Jim?
That is an out-of-this-world request, yeah. I mean, if you're giving it to somewhere that can actually receive it, then, that's fine. But I mean, if you gave it to ET on Mars, then obviously, that would obviously bring into question capacity. But as long as it's somewhere for that legacy and for those assets to land, then yeah, it's legally valid, subject to the will being created correctly and the person having the right state of mind when they created it.
Spot on. As long as the bequest is clear and the recipient can legally receive it, it's valid. And if the testator had capacity, even a UFO research fund can take off. Now, shall we dive into the next quirky inheritance? Let's talk about a chap who left his estate to fund the search for the Loch Ness monster. A true believer, he wanted his legacy to go towards proving Nessie's existence. How's that for a legendary legacy?
That's pretty out there. I mean, again, if there is such a research facility and there is such a charity that's actually designed to do that, then they would be able to receive that gift from that particular testator's will. If there isn't, then obviously it would fail. But I'm sure the other beneficiaries in the will might have something to say. So when was that will created?
That's a great point. The will was created in the 1970s when Nessie fever was at its peak. The estate ended up supporting various local initiatives. So it wasn't just about finding Nessie, but boosting the local community too.
Nice.
All right, let's dive into a case where a man left his estate to his cat. The feline inherited a cozy son with a caretaker name to look after it. How would you handle that kind of bequest?
Okay, when you're dealing with pets, if you're just giving a legacy to a pet in its entirety, then that's likely to fail due to the fact that, the pet can't actually receive the gift. But if you put it into a trust, then for the benefit of the animal, then that will suffice. And the rule of thumb here is just to make sure that the caretaker and the trustee are not one and the same, because then what they can do is they can obviously collude, euthanize the animal, and then take the inheritance from the trust, especially if they're the remainder man.
Great advice, Jim. Setting up a trust for the pet's benefit and appointing separate trustees and caretakers ensures everything's above board. Plus, it keeps the cat in the lap of luxury. Okay, Jim, time for some closing arguments with a punchline. Why did the will go to therapy? It had too many unresolved issues. Why do wills ever get lost? Because they always have a clause to find their way back.
That's actually quite good.
All right, folks, we've explored some truly unique inheritances today, from football clubs to Loch Ness monster funds. Next time, we'll dive into common mistakes to avoid when writing your will. Thanks for tuning into Wilful Speaking. Stay informed and stay tuned.
Thanks, Rosie.
You know, Jim, I tried to appoint a dog as an executor once, but he just buried the paperwork in the garden.